Proud Boys, day 36. The trial continues on. We're still waiting for the dust to settle. We had some pretty explosive issues that came out previously, many of them involving government malfeasance. Recalling what the biggest issues were, we've got 3 of them that I want to dive in on. Of course, this is the Proud Boys case. This is a big case. This was one of the groups, along with the Oath Keepers, that were castigated, blamed for being the seditious conspirators that were responsible for insurrecting America. We have this big, hyperbolic, whining, screeching that we've been hearing for the last 2+ years. Really has been centered around these 2 groups. And so this is a big group, and most of this was pretty mechanical, going through the motions out of the DC Circuit Court. Then suddenly, boom, turns out this FBI agent, Nicole Miller, this is just a placeholder photo. I don't know that this is actually her, but this is what we learned about her. Man, there were some pretty big issues from her testimony. And in one of the filings, I wanted to just recall that we heard that there were thousands of spreadsheet rows that were hidden from the defense. Remember, she testified, and then after her testimony, the rules say she's got to give a copy of the documents that she referenced over to the defense. She did that. There was like 20 rows in there, and when the defense cracked it open, they discovered that there was a whole additional slew of about 1,000 additional Excel rows that had been hidden. Very convenient. And so the defense was saying, oh, that's great. We can't wait to talk about all of this, because this shows that the government was hiding evidence from our defense, from our team. So that was an issue that popped up. We talked about that yesterday. There were also in those rows evidence of other messages that the government was saying, these conspiracy charges that we're working on here for the Proud Boys, they're pretty dang weak. They were saying, do you think this is going to get us over the hurdle of the conspiracy charge? You can see that right from the spreadsheet. Nicole Miller was saying all of that stuff. So we can actually go after them with conspiracy and not make a fool of ourselves, is what they were talking about. And they didn't think that was relevant, or that the defense should have seen that stuff. There were also issues that showed up in those deleted rows, about 338 items of evidence that just happened to be deleted. Weird. Showed up there. An FBI boss assigned Nicole Miller, this FBI agent, 338 items of evidence to delete. And then there was another request about deleting an attendee from a note. Said, did you write a report about that interview, about that conversation? Sure did. Can you take me out of there? I wasn't there, but you were there. That's why I included you in the report. Did you hear what I said? I wasn't there. Cut it out. So the email says, you need to go into the CHS report that you just put out and edit out that I was present. So all of these were pretty big issues. And of course, yesterday, we learned from the judge that they weren't really allowed to get into most of this. The hidden spreadsheet rows, the government said, hey, those are classified. Those are irrelevant. And the judge said, okay, that sounds good to me. And the defense said, can you prove that they're classified or irrelevant or any of these things? And they said, nope, they just said they were. And that's about as good as we need here in this jurisdiction. We also saw that the conspiracy charges, they said, were just irrelevant, sort of outside the scope. They talked about the deleted items of evidence. They said those are just old. No, those are old. They're like 20 years old, and they're not even related to this case. They're not even relevant. So don't worry about those. And they said that you can ask a little bit more details about this confidential human source, which is what we're going to get into big time today, because FBI agent Nicole Miller was still on the stand all throughout the proceedings today in this day of trial, day 36. We're going to go through that a lot. We're going to hear a lot from alleged liar Nicole Miller over at the FBI. We had another big issue, which we'll get into a little bit today, which was regarding Zachary Rehl's emails. Remember that the government prosecutors and, well, maybe we don't know about the prosecutors themselves, but the FBI agents at least were talking about reading the emails and then notifying the prosecutors about having read the emails. And they were saying things like, oh, this definitely looks like they're going to trial because they're talking about it. And they actually said that the defense attorney's raising some pretty interesting points, and they can't wait to pass those inside baseball tips up the chain so that they could go over to the prosecutor. Insane stuff. But they said, the government, that, oh, no, you signed a waiver. And so we flashed a waiver in front of your screen, which you see here in attachment A. And that simple waiver says responsibility. I must abide by all the terms in here. The computer system is the property of the DOJ. By accessing the system, I agree to everything and blah, 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 blah. True links. And by the way, our corrupt government is going to be reading your privileged emails, just so you know, tucked away in there somewhere. And so every single, I guess, defendant is just going, agree, just like you do on the websites or every time you install this, that, or the other thing. And then the DOJ just says, perfect. I guess that gives us access to everything. Do you see anything in here about alternative? I'd like to talk to my lawyer or something. Is there an alternative? Can I talk to my lawyer app that they have over there to just ping their lawyer? I don't think so. So, this is sort of, you have a captive person who's in your captive systems, and they're saying, well, he agreed to it. In order to talk to his lawyer, I'm guessing he's kind of got to go through this process, right? And so his attorney was communicating with him, and they were just listening in. It's disgusting behavior. Even if they had the legal ability to do it, it's disgusting behavior, right? It'd be like you going and getting the playbook of the other team and like you being allowed to do it. You say, well, they're using our locker rooms. They're using our locker rooms. And before they signed the locker room use terms, they said they agreed that we could just go into their lockers and just look around at everything. So therefore, we're doing it. And they agreed to do it. And so, sorry, sucks to be them. Now we know their entire playbook. And if they don't like it, maybe they shouldn't have come to play at our stadium. Except here, they didn't voluntarily show up. They shoved them in there. In my opinion, in an egregious manner, something that they should have never, these guys should have been released a long time ago. So completely captive, and the disgusting DOJ prosecutors, or I don't know if it was the prosecutors again. What we saw were the messages from the FBI agents. So let's say the disgusting FBI agents who are reading attorney-client privilege communication and then theorizing about whether to pass that up the chain of the command is so gross and reprehensible it makes my blood boil. But they did it because what are the consequences going to be? We'll see what the judge does. There was another big issue about new evidence that was being presented from the J6 tapes that Tucker Carlson shared with all of us finally. And they explained, the government responded, they said, you don't even worry about that stuff. It was all previously disclosed, and we don't know about this because we now have our doubts. We had our doubts previously about Chansley's first attorney, but now they're becoming a little bit more apparent. We watched him on Tucker Carlson, not too impressed with him either. And this is a situation where we don't know who got what or when or what the details were, but we're learning more about it. The question is, does the Chansley videos, does any of that relate? Does it pertain back over to the actual case at hand, which is the Proud Boys? So those were the big issues. I think they were very substantive, extremely frustrated yesterday that we didn't get any actual good rulings as a result of any of that. We're sitting here going, it's just like Christmas in America. Again, in this case, it's absolutely nuts because Elon is now retweeting free Jacob Chansley, right? Everybody's paying attention to this. The entire narrative, the fictional facade of the horrors of J6 are all starting to crumble down. That's why they're all petrified. They have to put up the force fields to make sure that they can put a lot of that stuff back. But everybody is now banging the table, say free Jacob Chansley, and pay some attention to these people because this is a travesty of justice. Now, many Republicans are still dead silent on this, and you expect them to be silent. But yesterday, we got familiar with how the judge ruled. The judge basically didn't even let some defense attorneys make a record in open court, just said, you're done. You've already had a chance to file your brief. Sit down. Somebody else stood up and said, another defense attorney, can I support him so he can finish his record? The judge said, why don't you sit down too? And they said, you already filed your briefs. So Julie Kelly, as we said, does excellent work on this, and she is really, plugged in on all of these issues, following a whole slew of cases. She's got access to transcripts, and she's giving some great analysis on Twitter. So if you're not already following her, please make sure to go do that. She's at Julie_Kelly2 on Twitter. This is exactly what it looks like. And she's posted this morning, March 14th, 6:30 in the morning. Man, she's up early. She said, hey, reading through the transcript from yesterday's trial, Judge Kelly's courtroom gymnastics to give the DOJ whatever it wanted and to omit incriminating FBI messages from evidence is ... something. Which is true. It definitely is. The DOJ offered not an ounce of proof this message pertained to a closed case. Judge said, don't even care. Right. And remember, this is related to that first issue that we talked about this 338 items of evidence. So apparently this is a clip from the transcript courtesy of Julie Kelly. She says that the judge said from the bench, gosh, he's really mulling this over now. Hasn't already ruled in favor of the government, basically every turn. Says on this point, another agent, he's ready from he goes, gosh, on this point, another agent messaged Agent Miller that her supervisor had assigned her to, quote, destroy 338 items of evidence. He said, that's a weird message, isn't it? Yeah. Well, I wonder what that's about. He says, but even though they said that, there's nothing in the record to suggest that the agent who sent this message was involved in this case, or that this destruction is related to evidence in this case. Okay. So he just says, well, she did say that, but we don't know exactly what she was talking about. So she could have been talking about any other case. And we're saying, yeah, or she could have been talking about this case or one of the J6 cases. And why is she deleting evidence? Can we talk about that? Can we communicate about this? Can this all be discussed in front of the jurors? Hello. And why was that in a hidden part of the message? The spreadsheets came over to the defense. Many things were hidden. That was one of them. Why'd they hide it? Well, they said there's nothing fishy there. The government, says the judge, he's up on the bench. He says, the government, by the way, 338 items of evidence, but we don't know who destroyed it or why they destroyed it, or even if it's relevant at all to the Proud Boys. And he says the government, again, here, they proffered an explanation. They gave us a reason. The comment related to evidence. They said it was in FBI custody from a nearly 20-year-old multi-defendant trial. And according to the government, disposing of the evidence in this case is just standard practice, right? It's just what the DOJ policy says that we're supposed to do when the case is completed and defendants' appeals have been exhausted. Oh, that's all. It's just deleted evidence. So the judge is just defaulting to the government. Just said, okay, well, all right, just 20-year-old evidence. And did they provide anything to explain that? Was there any more details on it? Julie says, defense noted that FBI agent Miller's reaction was not consistent with just a general housekeeping matter. Right now, we can't see this stuff. We're just observing this, right? This has all been done in open court and broadcast what I think is to an observation room where people like Roger Parloff, who we're going to get to next, are talking about it. But we can't see what's going on like we're able to see in the Rittenhouse trial or any of the other trials that we've talked about here. These are federal court cases, and so it's all behind closed doors. And so we can read the retweets, we can read Roger Parloff, we can read the transcripts even. But the defense is saying that when FBI agent Miller got called out on this stuff with the hidden rows, her reaction was not just like, oh, yeah, I sent you the wrong file. The old file had all the deleted things, and I just hid those, and then I deleted them because they were really irrelevant. I was talking about, it was basically my whole thing, my whole export from 2009 when I first joined the Bureau, so I deleted all those. She was freaked, man. And we read that. Nope, no idea what you're talking about. You didn't send those messages. Nope, no idea. Here's what the transcript said. The judge is continuing. This is the defense speaking. Mr. Smith, speaking for one of the Proud Boys, says, okay, judge, look, this is just the boss that's being referred to ordering the agent to destroy the evidence because the case is over. The witness's response when we asked her about those deleted messages, when we asked FBI agent Miller about this, her response is entirely inconsistent with that suggestion. In fact, they didn't just delete it, is what he's saying. If this was merely like cleaning out the drawers, the witness's response, says the defense, in all caps, oh my God, insane, which we're seeking to make an offer of proof to the court, does not follow. Because she's like, oh my God, insane. I don't know what that even means. It does not make any sense to say, oh my God, insane. I wonder if she said that. If we're merely destroying old tapes. So I guess maybe that came out. She's saying, oh my God, insane. Like they must have asked her, did you send this? Well, we have it here. And she said, oh my God, insane. That's insane. Because it wasn't housekeeping. It was actually, she had no idea what to say. I don't know. So the judge cuts him off and says, all right, Mr. Smith, all right, hold on a minute. Just so it's clear, all right, everything that you've described to me so far, it's either covered by my ruling as excluded under Rule 403, which we talked about yesterday as the probative versus prejudicial test, or I would do that. So he's basically saying, I'm going to kick that stuff out one way or the other. Another defense attorney, Mr. Root, stands up. He says, Judge, sending an email or a text saying that if that was what they meant was, my boss asked me to comply with the Bureau's retention policy. Let me start that over again because he just chimes in here. So this is another defense attorney, Mr. Roots, I believe is representing Pizzola. He says, sending an email or a text saying that if what they meant to say was, quote, my boss asked me to comply with the Bureau's retention policy and get rid of some old stuff that belongs to a 20-year-old case and deliver it back to the family. That would be a good message, right? Like that's what they could have said if that's what they were doing, which is funny because that's not what they were doing, right? They weren't just, closing out an old file, just clearing out those old bins, deleting some old evidence, He said, well, they could have just said, well, they were returning the case file back to the family and all of that. But they haven't stated that's the case at all. They haven't stated the family. The defense says, can we ask Judge for the record that they state right now what the case was and the family? Can you tell us if they're telling us that this is related to an old case? What case? Ask them. They say it doesn't pass the smell test. But the court chimes back in and says, Mr. Roots, defense lawyer, there's no evidence that they had anything to do with this case or anything to do with this agent, okay? It was just a spreadsheet row. We're talking about Jenks right now. So I've ruled on it and I'm not going to revisit the ruling, says the judge. So if you think that material is coming in, think again, buddy boy. You don't get to talk about those deleted materials or what that case is. And the government doesn't have to prove anything. Because it's the government. And I guess this judge just trusts them. Now, this judge, as we know, was a former DOJ prosecutor for quite some time. He was there and got a number of awards. And so, not saying he's biased or anything, but it's certainly interesting if you're going to default to believing, I don't believe that the government is default honorable. Ever, right? That's sort of my job as a defense attorney, is to always challenge that. No, we're not going to take your word for this at all. So the court is going to have to make decisions on this. Where is he defaulting? Can he possibly imagine that the DOJ and the FBI would be corrupt? I can, but he got awards from them. So maybe it's harder for him to do that. Now, Julie continues. She says, and the 80 messages that the DOJ unilaterally deleted under claims of classified and sensitive, which we talked all about yesterday. The judge, again, acquiesces to the DOJ as to how to handle the matter. An ex-DOJ official turned federal judge, as we read in his bio, says, how does the government think I should proceed? Here's what this looks like. Mr. Metcalf says, Judge, look, I don't know how to proceed in preparing my cross-examination if there's 80 different lines that have been taken out, and I don't know the classification for them. So if the government is just deleting these spreadsheet rows, I don't know why or what for, and they don't give me a basis for this, I can't do my job. I don't know what to ask questions about. Judge, can you help me? The court says, well, so that, one of the hanging issues here is that the issue of the removed lines. Yeah, it's a pretty big issue, Judge. He says, is the government planning, Mr. Pattis raised this last time. Mr. Pattis is on the defense. He's looking over to the government. Is the government planning, Mr. Pattis raised this last time, and is the government going to make, and he suggested, Mr. Pattis, that the government produce to me, or maybe to the parties and to me, but at least to me, a privilege log or something that describes the documents or the documents themselves so that I can review them. Where the judge is asking for a copy of the spreadsheet with the explanations about what the FBI deleted. And Mr. Pattis said, well, I would love a copy of that. So the court says, all right, let me that's the one I think, issue here that is sort of left hanging. Well, how does the government want to address? Turns over to the prosecutor. I don't know what to do here. So what do you want to do, government? How would the government suggest that you address your deleting of rows of evidence? You guys deleted the evidence. What do you think we should do? Great. So what do they say? How would the government suggest that get addressed? It doesn't. Well, how does the government think I should proceed as to those documents? Just turning it over to them. And I guess this is what the DOJ finishes with. Says the DOJ says the deleted messages were either classified or they were about sources and methods, so they can't be revealed. And by the way, the defense can't see them because they don't have security clearance. Here's what they said. So that's what Julie shares with us from the transcripts. And the court says, Okay, that sounds great. Okay, so they're classified and they're also sources and methods, and the defense doesn't have any classified security clearances. And the judge is like, oh, that's perfect. That's great. That answers everything. So we don't even have to worry about those lines that you deleted on your own. The defense has some issues over it, but you deleted them, and you know better than we do. And we trust you because you're the DOJ and I used to work with you guys and you guys are awesome. Thank you for the awards. Good to be hanging out with you again. Welcome to my courtroom. You guys are doing great, by the way. Nice job. Call me after it's over. And they're, Judge, yeah, no, it's all classified. They're all looking at each other. All the prosecutors are like, can you believe this crap? I said they were classified. I said that they were sensitive. So they're all mocking each other. And the judge goes, oh, perfect. That means it's like 80 rows, right? That means it's like 80 messages. Prosecutor says, yeah, it's about 80. Perfect. All right. But. So the prosecutor says not the exact number. And I would note that everything removed was either classified or pertained to sources and methods, or the FBI internal file pass that would likely not be accessed from a browser anyhow. And none of them were even sent by Agent Miller, and none were within the scope of her direct testimony, and we don't believe any were required to be produced to these defendants anyways. And the judge says, okay, perfect. Great. All we need to know. And of course, that is the end of the transcript. And so, as we say, go follow Julie Kelly to read the rest of the story from her, because she's going to close that out with some additional knowledge over there about what took place. And so Julie Kelly at Julie_Kelly2 on Twitter to read the rest of yesterday's transcripts, courtesy of her. But let's turn our attention to one of the more recent filings that took place today. We'll see what the court docket had in store for us here, and we'll actually do a refresh to see if there's anything that has hit the docket in the last 28 minutes since we started the program. And no. So we do have a minute entry. This is regarding a witness who was going to be trying to quash a subpoena that's been withdrawn. Yesterday we left off. We saw that there were a whole slew of arguments, which we're going to dig into a little bit further because there's more cross-examination of the FBI agent. But this was the last filing. You see here, this was a motion that came in from Proud Boy defendant Joseph Biggs. He was asking the court for an admonition. You see, this is what that looks like. Very short filing, 2 pages. Filed on March 13th. This is from Joseph Biggs. His attorney is Daniel Hull out of Washington, D.C. He says that, Judge, new developments, news and commentary, and lively public debate on that awesome live stream called Watching the Watchers Live. Just kidding. Says that concerning events on the Capitol, they've appeared in the media repeatedly, and now a lot of people are talking about it. Accordingly, Biggs requests that the jury be given jury instructions at the end of every day, saying that, as always, conduct no discussion about any evidence, don't do any independent investigation, please avoid the media, signed off on by Biggs's defense attorney going into the court. So that's basically the only new real filing that we see coming out of this.